the deceased. Core data shows he met the deceased. The first accused person is alleged to have told witness number 7, Owen, "I stay in Emali. Evidence reveals the contrary." The first accused person gives the reason why he's wearing a kanzu and says, "I'm going to meet people in Isli, from Muslim community." He does not reach Isli. It turns out the kanzu was worn, left, went where he went, came back, and in fact, by the time he's going to meet the second accused person and the others in Westlands at midnight, he has also removed the kanzu. For training, the gun is found evidently at the time the offense is being committed, at the scene of the offense. And of course, his own confession, "I lied about the gun shooting." The second accused person contradicts her own statement by the statement of 30th and says, 29th, now I'm clear in my mind. The statement I gave you yesterday was a lie. Statement of 28th was produced as exhibit 109. Statement of 29th was produced as exhibit number 10. Once it's produced in evidence as exhibit, I use it. Before I move to the very last tale of my judgment, allow me to address the issue of contradictions and the law. It is the first accused, and by extension, of course, the second accused again says, "Look at all these contradictions in the case of the prosecution," and found that the prosecution have not proved their case beyond reasonable doubt. The case of John Nyagan Juki and 4 others versus Republic. The court says this: in certain criminal cases, particularly those which involve many witnesses, discrepancies are in many instances inevitable. I'll read again. In certain criminal cases, particularly those that involve many witnesses, discrepancies are in many instances inevitable. Philip Nzioka Watu versus Republic. Court of Appeal had this to say on contradictions. However, it must be remembered that when it comes to human recollection, not witnesses recall exactly the same thing to the minutest detail. Some discrepancies must be expected because human recollection is not infallible, and no two people perceive the same phenomena exactly the same way. Joseph Maina Mangi versus Republic. Lays the legal principle that the court will not disregard the evidence of a witness on the ground of contradictions unless the contradictions go to the root of the case and create doubt as to the guilty of an accused person. And the court had this to say on that. In any trial, there are bound to be discrepancies. An appellant court, in considering these discrepancies, must be guided by the wording of Section 382 of the Criminal Procedure Code. Where such discrepancies are such as to cause prejudice to the appellant, or if they are inconsequential to the conviction and sentence. What are these contradictions this court has been invited to look at? Contradiction on the time Harold went to the house of the deceased. Contradiction on the clothes. Some people say he had a counsel, others didn't say he had a counsel. Contradiction, one witness said, I saw him with a bag, another one, I didn't see him with a bag. In my finding, and it is the finding of this court, the contradictions the defense has invited this court to look at are inconsequential. They do not go to the root of the matter, and the evidence of the witnesses cannot be disregarded on that ground. I am expected to be bringing the curtain down, but I'll go to the last ingredients, those of us who are working with me. And I have to pose a question and answer at this point. Then I'll come and answer that question. And I will repeat the question. Did the first and second accused person kill the deceased? I will answer it. But if, before I answer that question, let's look at the last element of malice aforethought. I'll look at two things, then I will close. I'm sure you're wondering what is the next thing she's going to look at, so let me whet your appetite. I'll look at malice aforethought, I'll look at circumstantial evidence, then I'll close. I'm sure the lawyers understand why this judgment had to be this long. There was no option out of it. Please join me in looking at section 206 of the Penal Code. And just to save a bit of time, I will not read because I've captured it from the law. Please allow me not to read, I pass. But it talks about malice aforethought shall be deemed to be established by evidence proving any of the following, then it gives the circumstances. Please allow me not to read. But maybe I need to just point out subsection C, an intent to commit a felony. So you'll be deemed to have had malice aforethought if your intention was to commit a felony. Now, in the instant case, what the prosecution are arguing is that even before the day of the murder, the first accused person had already started preparing premeditation. And so, how do they support their submission to that effect? We go back where we were earlier. Look at his conduct before. Look at his conduct during. And look at his conduct after. So let's just do a recap. The first thing is that the first accused person, and I've made a finding on that and we don't have to belabor it. The first accused person stole the ID of Dominic Bisera Harold on 17th of September, 2 days before the murder. And why this court has arrived at the conclusion that he stole the ID is because of two things. One, he resides within the Royal Park estate where the ID was stolen. Is it a coincidence? Number two, the ID was never recovered. The owner had to get a duplicate. And number three, the witnesses to whom he presented that stolen ID have identified him on the ID parade as the person who presented the ID. So it's not hard to join the thread. And my finding is that the first accused person stole the ID of Dominic Bisera Harold 2 days before the commission of the offense. Secondly, the evidence analyzed reveals that this first accused person, other than the cloth he was wearing, he carried a bag, and the house help has testified that he had a bag. That evidence of the house help has been corroborated by the evidence of Jennings, whom he joined and who was his friend. And Jennings says yes, he had a bag, and it's in that bag that he removed a counsel. So the question is, why didn't he wear a counsel right from the time he left home? Does the carrying of the counsel to be warned murder and remove immediately the murder part of the plan? Does it constitute? Number 3, it is evident that he had borrowed a gun from Kasaini. He was supposed to return the gun after 2 days. He didn't. Then just before he went to the deceased house, he took the gun and went with it. Does the fact that he borrowed this gun even before the due date, or the material date, or the fateful night, part of his plan to commit the murder? The statement to Owen. In other countries, you can commit an offense and walk out with it. You can't walk out with it, but in Kenya, you can commit an offense and walk out with it. Because, and even impersonate, no one would really follow you. We don't have that. What does it speak to? Number 5. The evidence of Jennings. He was left and he says when the accused person came back, he told him that he had quarreled with a girlfriend from South Sudan. But even more so, that when he came back, he looked agitated, he was not in the mood, and seems to be in a hurry, and he didn't want to advance anymore the discussion they had. Republic versus Richard Itweka, Wahiti. Does the nature of the injuries that the deceased suffered speak to malice aforethought? That case, the court held that severity of the injuries is evident that they were inflicted by a person who had no any other intention than to cause grievous harm and kill. Let's look at the injuries the deceased suffered. I'll take you to the doctor's evidence. I picked this from the post-mortem report. But the deceased airwave had been shot through and through. And the right carotid and the jugular veins had been severed. That is cut through and through. Now this brings me to what played before this court heavily as I have this case. On very many occasions and during cross-examination, the counsel for the first accused person kept on putting to the witnesses, have we ever slaughtered a goat? And the witnesses would say, yes. And what impression was created in the court's mind? That the manner in which the deceased was killed was akin to slaughtering a goat. And so the argument of the first defendants, accused, was that if I really killed her the way she was killed, the way a goat is killed, how come the blood didn't go on my cloth? I have had the benefit of looking at the photographs by the scene of crime. And it's very clear that the deceased and the person who killed the deceased did not intend to give her room even for 1 minute to survive. Now, I've said Dr. Nzioka said that the airwaves and the jugular veins were cut through and through. So I checked on the functionalities of these organs that were targeted. And this is what I found. The carotid arteries are major blood vessels that provide one's brain, supply blood to the brain. I established that a person has 2 of them on either side of the neck. I discovered that they're actually a cause of at least 1/3 of all strokes. And that a stroke occurs when something blocks blood flow to your brain and causes brain injury. Therefore, they are a very important part of one's circulatory system that sends oxygen-rich blood to organs and tissue in the head and in the neck, including the brain. And then checked on the veins that were targeted. And I discovered from my search and reading, they are major blood vessels that stretch from the upper head, from the head to the upper chest. There are 3 pairs, total of 6. And the reading, my further reading shows that when the arteries and the veins that were injured on the deceased body are severed or they are cut, then no blood is supplied and the victim cannot even survive for a minute. It's my considered observation, opinion, and finding. And it's noteworthy that this deceased person had injury on the neck only, occasioned by a sharp object. It is my considered opinion the target of the neck clearly indicates that the perpetrator was fully aware, intended to, and did actually target for purposes of instant death of the deceased person. Thus, this connotes malice aforethought. I did, and I've made an observation. When you look at those photographs, you don't want to look at them again. The slitting of the neck was not just on the front, right up to the back. And I made an observation. It's no wonder then in our hearing we heard of slaughtering of a cow or a goat. The evidence of Chief Inspector Otieno is that the person who committed this offense was not an amateur. He's not a person who has no training in military, because the way it was done with such precision that you can't go wrong. And so I asked myself, does the first and or the second accused person have any training in military or military training? And that took me to the following. According to the evidence of the prosecution witnesses, and I'll start with the evidence of Jennings, when he met the first accused person, they were on a VIP protection exercise, and it said that that is when the US president was in Kenya. And he says They then became friends, and they were actually discussing how to form a security company. The house help says in her evidence, she asked the second accused person what the first accused person was doing, and the second accused person told her he's a soldier in Dubai. Owen says the deceased introduced the first accused person as a security in Interpol and Office of the President. In fact, according to Owen, they even spoke how he was going to help this witness secure a firearm. Jennings says that the first accused person told him that he had been working with a security company in Dubai. And he also told him that he was offering VIP protection to state officials in Kenya while on leave. According to Kasaini, he gave the first accused person a gun because he knew the first accused person was working as a private military officer who covered several politicians under an undercover, so to speak. That he worked as a private military contractor in Dubai and was guarding the former Senator Joyce Ray. It is the finding of this court that for one to engage in VIP training, they definitely must, protection, they definitely must go through training. And that training would not be too far away from the training offered to a military officer. And if the first accused person went through this and he murdered the deceased, then he had the know-how. The conduct of the first accused person and his conversation with the deceased brother. When the deceased brother told him, look, can you help me get press? Can you ask your fiancé who is in the media industry? It is in evidence the first accused person told me, forget about the media, they won't help you. I don't know, you are here. I have a private company, let me do it for you. What does that statement speak to? A further issue I picked up, he says, look, the person whom the deceased allowed into her house was Dominic Becerra Harun. And she must have known somebody by that name, and that's not me. And my simple finding on this is this. If this first accused person is introducing himself, I work at State House, I protect the President of the States of America, I am in a security company, I am an undercover, is it far-fetched to imagine that even when he told the guards at Ramuria Gardens, I am Harun, the deceased would not have contradicted that because the deceased also introduced him as somebody who works at State House. So we all know that, hopefully, the court is making a right observation, I think I am, that people who work as undercovers will not quickly volunteer their true identity. And that could inform why, even when he said I'm Harun, and the deceased knowing whom he has said he is, would quickly say, let Harun come in. And then in the house gives him his true identity to the other persons in the house as well. So I didn't find it difficult in coming to a conclusion that it is explainable. Is this case based purely on circumstantial evidence? And has the prosecution met the threshold of circumstantial evidence? You'll allow me to just pick extracts from the cases. I'm coming to the tail end of my judgment. Cases that speak to circumstantial evidence. Some very critical areas I think will guide my findings. and another versus Republic 2019, speaks to circumstantial evidence is often the best evidence. It is evidence of surrounding circumstances which, by intensified examination, is capable of proving a proposition with the accuracy of mathematics. It is no derogation from evidence to say that it's circumstantial. Republic versus Juma Kaviha Kalama. Circumstantial evidence is particularly powerful when it proves a variety of different facts, all of which point to the same conclusion. I have given my own emphasis on the following. It works by cumulatively in geometrical progression against other possibilities that has been likened to a rope composed of several cords. One strand of a cord might be insufficient to sustain the weight, but 3 strands put together may be quite of sufficient strength. There may be a combination of circumstances, no one of which would raise a reasonable suspicion, but the 3 taken together may create a strong conclusion of guilt with as much certainty as human affairs can require or admit. Emphasis added. Having considered the evidence in this matter, it is the finding of this court, yes. The case is based on circumstantial evidence, but the prosecution has adduced adequate evidence and has met the threshold. And to sum up, did the first accused person kill the deceased? It is the finding of this court. I'll play back for purposes of my finding. The first accused person stole the ID of Dominic Becerra 2 days prior to the commission of the offense, armed himself with a gun, carried a counsel, put it over his cloth, went to Amoria Gardens, disguised his identity, gained access to the apartment of the deceased, murdered the deceased, left the deceased house, changed his clothes, and eventually went home and burnt the cloth which he wore during the commission of the offense. It is the finding of this court that all this evidence taken cumulatively leads to a strong conclusion that the first accused person murdered the deceased. And therefore, it is the finding of this court that the prosecution has proved beyond reasonable doubt all the ingredients of the offense of murder. The death occurred, the cause of that death, the person who, and in this case the first accused, I'm still on the first accused person, committed that offense, it was not a case of homicide, excusable homicide, it was unlawful. And therefore I find the first accused person guilty as charged herein of the offense of murder, that on the night of 19th of September 2018, at an unknown time at Ramoria Gardens apartment, he turned away off Dennis Pitt, With others know before this court, he murdered Monica Nyawira Kimani. The evidence by the prosecution against the second accused person did not place the second accused person in the house of the deceased on the material night. There was no evidence that she had ever communicated with the deceased. The evidence that the prosecution have brought before this court on the second accused person relates to the events of 20th of September 2018, and that is the shooting incident. And in that regard, having considered the provisions of Section 129 of the Penal Code of Kenya, and the second accused person having had no objection to her two statements which she gave the police, one saying that the second accused person, the first accused, was shot in the house, and then retracting that statement the following day, only leads this court to the provisions of Section 129 of the Penal Code, which states as follows. That Section 128 creates an offense, which is an offense of giving information, false information, to a person employed in public service, and states as follows. Whoever gives to any person employed in public service any information which he knows or believes to be false, intending thereby to cause or knowing it to be likely that he will thereby cause the person employed in public service A, to do or omit to do something which the person employed in public service ought not to do, or omit, if true state of facts respecting which such information is given or known to him, or two, to use lawful power of the person employed in public service to the injury or annoyance of another, is guilty of a misdemeanor and liable to imprisonment for 3 years. The statement which the second accused person gave to the police on 28th was false. The statement was given to a person in public service. The statement intended that that person investigates that offense. That statement was retracted by the second accused person the following day by a different statement, now speaking to what is said to be the truth. There is no timelines in criminal law when you can prefer a charge against a suspect. The Limitation of Actions Act does not apply to criminal offenses. It is my considered view that the charge brought against the second accused person was not the proper charge. Section 157, sorry, not section, Article 157 gives the power to institute and prosecute a person suspected of committing the offense to the office of the Director of Public Prosecution. And the question posed at this stage is, was there any offense committed when the second accused person gave a statement to the investigating officers at Langata Police Station, which turned out to be not true? I say no more. The office of the Director of Public Prosecution know their mandate. The result is that the prosecution did not adduce adequate evidence for this court to find the second accused person guilty of the offense of murder of Monica Nyawira Kimani on the night of 19th of September 2018. The first accused person is convicted on the charge. The second accused person is acquitted of the offense. That is the end of the judgment. We'll move to the next stage. The state you are supposed to go next.
Yes, we are the first ones.
So I am expecting the records. If any.
We'll be asking for more time. To present CRO report, which is the previous records for the first accused person who has been convicted. In the meantime, we'll also be asking for a pre-sentence report in relation to the first accused. And we'll also be praying that the first accused be remanded